He took their money and was supposed to build them a pool. Instead, he's been convicted of felonies. I'm Fox 13 investigative reporter Nate Carlisle. And this is
Rob Riley, Triton Pool and Spa.
Back in 2023. And here's one of the pools prosecutors say he took money for, $62,000 from a family in Far West, and didn't finish.
Robert Patrick Riley.
And this was Riley on Wednesday. He was charged with crimes after our story aired. Last month, a jury in Ogden convicted Riley of theft by deception and one count of communications fraud. He faces up to 30 years in prison, though his sentencing isn't scheduled yet. Riley has 5 other criminal cases pending in Weber and Davis counties, according to court records. He's pleaded not guilty in those. His attorney declined comment after court Wednesday. For now, Riley is being held in the Weber County Jail.
I do believe with this case that it is groundbreaking. I think with maybe the outcome of this will help other people that have been in the same situation as us, I hope.
Just a few of the people who say they were victims of Riley attended Wednesday's scheduling hearing. Tiffany Fligger of North Ogden filed a civil lawsuit against Riley and won a $42,500 judgment. She's still trying to collect.
I do believe with this case that it is groundbreaking. I think with maybe the outcome of this will help other people that have been in the same situation as us, I hope. The lessons we've learned: do your research. When you hire anyone to do anything small or large, do your research. Search first for, if they have a license, that it's valid. Does the license cover what he's going to do at your home?
As for where the money went, court filings show Riley just spent it on personal expenses for himself and his family. At the state courthouse in Ogden, Nate Carlisle, Fox 13 News.
Welcome to IRA episode 121. I am your host, Goel. And in this episode, we examine the disparity between the case that you just saw an opening for. That is the allegation against Robert Patrick Riley that he defrauded multiple families in terms of contracts that he entered into to build 4 swimming pools. So Robert Patrick Riley defrauded those families. There's no disputing that. He's been convicted. He's facing 4 to 60 years in prison plus $294,674 in restitution, plus interest to his 4 victims who hired him to build pools that he never actually constructed. So let's take a look at the disparity between what Robert Patrick Riley did in that case and what has been done in the case of former Ogden School Resource Officer and Special Victims Unit Officer Colton Johansson, who got 30 days with 2 days of time served credited to his sentence for sexually abusing an infant in Roy in 1994 and for possessing child sexual abuse material in the present day as a school resource officer. Let's unpack that, shall we?
Tonight, an Ogden school resource officer is out on bail after he was arrested on several charges, including sexual exploitation of a minor. News specialist Brianna Chavez live for us in Davis County. And Brianna, do they have a reason to believe that any of the Ogden students were involved?
Well, Mike, as of right now, no, but a Davis County Sheriff's spokesperson tells me that it is still early in this investigation.
Ogden police say a school resource officer, Colton Johansson, was terminated after he was arrested by Davis County deputies Thursday.
About a week ago, the Davis County Sheriff's Office was asked to investigate a conflict case for the Ogden Police Department regarding a current law enforcement officer.
Johansson is facing multiple charges, including 10 counts of sexual exploitation. KSL interviewed him for a story back in 2021. Charging documents state Johansson admitted during a polygraph test that he had taken home a box of case files which contained hundreds of images of child sexual abuse material. The Davis County Sheriff's Office said Johansson had been an officer for more than 30 years.
His most recent assignment was as a school resource officer. Prior to that, he did investigate special victims cases.
In a statement, the Ogden School District said Johansson was assigned to Ogden High School.
At this time, we don't have any reason to believe that the evidence that he was maintaining had contained children that he had worked with in his capacity as a school resource officer.
Davis County says they're taking this case seriously.
We understand that this is a very sensitive case, especially involving a law enforcement officer, and we are very respectful of that. But a lot of things did occur right in this situation. Ogden PD has been very transparent from the beginning and immediately turned this over.
And the school district tells me that Ogden Police Department has already replaced another resource officer replaced Johansson, I should say, with another school resource officer at Ogden High School, and a counseling team is available for students who need their resources. Mike.
Yeah, disturbing allegations there. Brianna, thank you.
There you have it. The Ogden police were incredibly transparent as it pertained to the allegations against Colton Johansson. And they did their job. They conflicted the case. Obviously, they can investigate one of their own who allegedly sexually abused an infant in Roy, Utah, 30 years ago, and who had child sexual abuse material in his garage, so much so that it was disrupting his polygraph during what was effectively a job interview for a lateral position. I mean, they conflicted themselves out. Davis County sheriffs took over. And let's unpack Colton Johansson. Judge Catherine Coughlin, the judge in Colton Johansson's case, held that he was not a threat to the community, even though he raped an infant by his own admission, sexually abused an infant. He's not a threat to the community. And Robert Patrick Riley, a pool contractor who defrauded 4 people of their money in exchange for pools that he never built. He faces 4 to 60 years in prison, but a guy who sexually abuses an infant and possesses child sexual abuse material, he gets 30 days with credit for time served on 2 days. So 28 days in county jail and another 60 days of home confinement monitored by GPS. You can't make this shit up. And the theme of today's episode is why Utah is screwed. So let's unpack who Colton Johansson is. Let's unpack that for our viewers, okay? So Colton Johansson, in his polygraph, divulged that he had abused an infant in Roy 30 years ago. That's the reason he said he was flunking his polygraph when the examiner stopped the polygraph. Well, he had that on his conscience. He sexually abused an infant. And what should be really chilling about that is that prior to his work as a school resource officer, Colton Johansson was working with a special victims unit at the Ogden Police Department. So here's a guy who's tasked with investigating sexual predators, rapists, child sexual abusers, people who possess child sexual abuse material, and he himself is guilty of forcible sexual abuse against an infant. That's Utah. And, he didn't do anything as serious as defraud people out of their money by entering into fraudulent pool building or pool construction contracts. He just forcibly sexually abused an infant in Roy in 1994. So his 30-day jail sentence with 2 days of credit for time served, completely reasonable. Meanwhile, the real threats to society are men like Robert Patrick Riley, who defraud people of their money by entering into agreements to build pools for them and not building the pools. And he gets 4 to 60 years worth of imprisonment, while Colton Johansson, who sexually abused an infant, gets a mere 30 days plus 60 days of home confinement with GPS monitoring. Ladies and gentlemen, that's why Utah is screwed. But, like the former pitchman, while he was alive, Billy Mays would say, but wait, there's more. There's always more. And so, as we examine Colton Johansson's past, and, a simple court search that any journalist could find, if they just did a simple court record search, they would find that Colton Johansson had 2 prior divorces, that his ex-wife, Kathy Johansson, had apparently filed a civil stalking injunction, which, to be fair, was denied. And the reason for it, given in the court documents, was that Colton had not threatened her with any physical harm. As you do. I mean, clearly she felt threatened enough to go to apply for a civil stalking injunction. Whether or not his status as a police officer had any bearing on that, that's another matter. It is, anybody who examines these matters involving law enforcement ultimately will find that police officers tend to get kid gloves treatments when it comes to domestic violence and civil stalking, or stalking cases in general. They tend to get that home cooking, that home court cooking in terms of the courts. And, of course, that apparently extended to Colton Johansson's sentence by Judge Catherine Conklin for forcibly sexually abusing an infant and for taking child porn to his house under the bullshit pretense that, they don't have room for it. They don't want it to be stored in the evidence locker at the police department, which, by the way, the current Ogden City Police Department chief disputed. This is what Chief Jake Subi said in his statement. Former officer Colton Johansson's conduct was indefensible. It was a serious violation of the law, department policy. It is entirely inconsistent with the standards of the Ogden Police Department and the law enforcement profession. So, Subi goes on to say that he was placed on administrative leave before being terminated within days. He also critiqued Judge Conklin's sentence. The outcome in this case does not reflect the seriousness of the criminal conduct and falls far short of the accountability the public in this profession should expect. The outcome was not the result that this department sought, and it is not one we support. The protection of victims, especially children, is not just a priority for this agency. It is our most fundamental responsibility, and we will act immediately and decisively whenever trust is violated. So, the former Ogden City Police Department chief, Randy Watt, you should probably check his computer, he made statements at Colton Johansson's sentencing, and he was in support of Colton Johansson. He said, Colton's not that bad of a guy. You know, I mean, he forcibly sexually abused that infant in Roy. That's what he confessed to 30 years ago in 94, but he's been exemplary ever since. Chief Subi, the current police chief, disputed Colton Johansson's statement that officers were permitted to store evidence in their homes. This is his exact quote. There has never been a policy, practice, or authorization permitting an officer to store evidence, including child sexual abuse material, at a personal residence, in a vehicle garage, or any other non-secure location. Any suggestion that such conduct was permitted, accepted, or consistent with department practice is inaccurate. That's Utah. Colton Johansson got 28 days in jail, effectively, for the forcible sexual abuse of an infant and for taking child sexual abuse material home. And by his own admission, he was gratifying himself in his garage to this material and, you know, masturbating to it. But, you know, he wants you to believe that actually he pilfered through all of that sexual abuse material in order to get the portions of it that depicted adults in a sexual or unclothed light. And that was what he was pleasuring himself to. Yeah, he molested that kid in Roy, that infant in Roy, 30 years ago, but that was a one-off. It only happened the one time. That's all it was. Shit. Who hasn't raped an infant, you know, in their 20s and then gone, you know, 30 years between incidents of abuse? But if you defraud people out of their money in the state of Utah by entering into contracts to build pools that you don't build, I mean, we take that seriously. 40 to 60 years imprisonment plus roughly $295,000 in restitution. That's the fucking level. That's why this state is so screwed. Like, at the end of the day, that's what's going on in this state. You get 28 days in jail for raping an infant or forcibly sexually abusing an infant 30 years ago. By your own admission, you admitted to it. You said that this happened when you were talking to a polygraph examiner over why your polygraph was fucked. That's the reality. That's what's going on. But if you don't build somebody's pool after entering into a contract with them, you get 4 to 60 years. You forcibly sexually abuse an infant and you possess child porn, you get like 30 days in county jail with 2 days of credit for time served, and you get another 60 days with a GPS monitor. Seems like that adds up, you know. And by the way, Judge Catherine Conklin, in justifying her extremely lenient sentence to Colton Johansson, she stipulated that she did not find him to be a danger to the community. I mean, imagine that, a guy who admitted to sexually abusing an infant in Roy in 1994. He's not a danger to the community. But that pool contractor who defrauded people out of their money and didn't build their pools, I mean, he's a real threat to the community. I mean, you can't have people defrauding people out of their pools. I mean, that's fucking serious business. If it seems like there's a really disproportionate disparity there in sentencing, it's because there fucking is. Like, it's because this state has its priorities all askew in terms of in terms of how it treats sexual abuse. 2.97% conviction rate with rape. And why would you come forward if you were a child, like years later, to report your abuser when you see that Judge Catherine Conklin doesn't think that a guy who forcibly sexually abused an infant 30 years beforehand and had child porn in his possession is a threat to the community? Why would you even fucking bother? Like, why would you bother coming forward and reporting your abuser when you see shit like this and you know that this state has an under 13% prosecution rate for rape, all forms of rape, including child rape, and they're just handing out 30-day sentences to people who forcibly sexually abuse infants and have child porn. Like, there's no disputing that Colton Johansson did this. He confessed when he was bombing his polygraph. He confessed to the polygraph examiner what he did to that infant. Now, was he completely forthcoming? Probably not. But what he confessed to is bad enough. He sexually abused a fucking infant, a baby. And then 30 years later admits to having child porn in his garage. And he makes up a bullshit story that the reason he had that evidence in his garage, material that he procured in his work as a special victims unit police officer or investigator, that's where he got this material. The reason he stored it in his garage at home is because there just wasn't any room for it in the evidence locker at the police station. There wasn't any space for it, and the police department has a policy that they don't like that kind of material to be stored in their evidence locker, which was an obviously bullshit story. But it gets better because, ironically, like, unbelievably, people wrote letters of support for Colton Johansson. Like, that's the thing that's really stunning about this. The more I've dug into it, the more I've realized just how screwed this state is. So I want to read some of the letters of support. So this is Carly Crudell, the third child of Colton Johansson. This is what she wrote to Judge Catherine Conklin in support of her father. My name is Carly Crudell. I am a homemaker currently living in Maryland with my husband and 2 dogs. I'm Colton Johansson's third child. When I was first told what my father did, I was shocked and confused. When I learned more of what he was done, I was heartbroken. I could not imagine that my dad, the man who raised me, the school cop, could be capable of something so awful. His actions have caused immense stress and public embarrassment for me and my family over the past year. I have also never seen my dad so sad. He tries to hide it, but I can see how low he really is. Growing up, my parents were divorced, and I lived mostly with my mother throughout junior high and high school. Well, thank fucking God for that. For a time, I was mad at my parents. My father never held that against me. I knew then, as I know now, that if I needed him, he would be there for me. You know, what do you want to give him? You want to give him a cookie? You want to give him a certificate? He's a dad. He's your dad. He's supposed to be there for you. I knew then, as I know now, that if I needed him, he would be there for me. When I was in high school on a snowy night, I spun off the road and was stuck in a ditch. It was 3 a.m., and my dad was the only person who would answer the phone and come to my rescue. Well, there's your fucking sign about the dysfunction in that family. Your kid is calling you at 3 a.m., and they're high school aged, and it's snowing, and you don't go looking for them when they're out at 3 a.m. on a snowy night. The only person in their family is the dad, who is a child sexual abuser and who has child porn in his garage. He was the school cop at my high school. Well, Isn't that fucking great? My friends and other students would often go to my dad because they felt safe at school. When my husband was on a 7-month military deployment, I broke my ankle and was unable to drive. He let me move back in, helping me through my medical issues and encouraging me when I needed it most. When my husband and I were going through IVF, in vitro fertilization, he had whoever was willing fast and pray for us. Well, isn't that nice? Doesn't that minimize or mitigate the fact that he sexually abused an infant in 1994? He has helped each and every one of us, one of his kids at some point. What the fuck does that have to do with anything? You never have to ask to stay at his house. You know a room is always available. It is a safe place any of us can go to. Well, Carly, would you let your kids stay with their granddad knowing what you know now about his propensity for sexually abusing infants by his own admission? Or, having child porn in the garage that they might stumble across? This letter, this does not diminish what he has done to our family and this community. How about his victim? This is the thing that is bereft of a lot of these letters of support. There's no mention of any victim. This man sexually abused an infant in 1994. I wanted to write this letter to recognize that he has done a lot of good things as well. Well, no amount of good things you've done is going to overcome the fact that in 1994, you sexually abused an infant. I wanted to write this for the man who has always been there for me when I needed him the most, my dad. A lot of sexual predators are there for their kids. A lot of sexual predators are upstanding members of their community outwardly. That doesn't change the fact that they rape fucking kids or that they create a demand for child porn, the supply of which always involves the abuse of children. So here's Hailey Olmedo. She wrote a letter of support on behalf of Colton. My name is Heidi Olmedo. I am writing this letter on behalf of Colton Johansson. He is a friend and former co-worker of mine. Colton has always been kind, respectful, and a man of his word in all my dealings with him in the 22 years of friendship and work dealing. If I can provide additional information, please do not hesitate to contact me. She gives her phone number. Have some ex-parte communication with me, Judge Conklin, outside of anything that the prosecutors are aware of, so on and so forth. At a time when most people would be walking away from Colton Johansson, Heidi is running towards him. He's always been kind, respectful, and a man of his word. So when he was lying to you about his proclivities for children by omission or existing in plain sight as someone who had sexually abused a child, an infant in 1994, who had child porn in his home, when he was deceiving you by being kind and respectful and a man of his word in all dealings over the 22 years that you knew him, he failed to mention the fact that he sexually abused an infant or he had a proclivity for having child porn in his house. Does that change your opinion? Apparently not if you're Heidi Olmedo. Here's Jed Johansson, Colton's brother. He says that Colton is someone that he looked up to his entire life. Colton has been a very influential person to me and my family. I don't know if you really want to say that, given that your brother molested a kid and had child porn. I know Colton is a good man and has many wonderful attributes. Well, good men don't molest infants. Good men don't keep child porn in their garage. Colton has been a caretaker to my aging parents. They need constant and consistent support. Colton has spent many hours of his free time to take them to doctor's appointments, care for their property, and provide them with a myriad of little things that they have needed. My family is very appreciative to him for his help. Colton has taught many classes to my students when I was a principal of a school on his own time. Are you fucking clueless? Seriously? This is a guy who molested a kid, an infant of all things, in 1994. And you're going to put in your letter of support, oh, he taught classes to my students when I was a principal of a high school. Or as a principal of school. He took his own time. No shit. He took time out of his own life to teach your students and put himself in proximity to children. As someone who has child sexual abuse material, child porn in his garage, and who forcibly sexually abused an infant, at least one that he admits to. I asked Colton to teach different classes, and he did so willingly and was an effective teacher to help kids to know the difference between right and wrong, and provided much-needed guidance to a young student body. It's like these people just aren't operating in reality. Colton has also been a huge supporter of me during the very difficult times in my life. I have relied on him, and I don't know what I would have done without him. He is not a good brother. He is a great brother. I know Colton has made mistakes, as we have all done, but the good that Colton has brought the world far outweighs the bad, and I'm hoping the court system will see his remarkable value to society and his loved ones. There are no fucking words when you read this. Here's Rod Layton. Rod Layton wrote a multiple page, I think it's 5 or 6 pages, 4 or 5 pages actually. And Rod Layton, I was employed with the Weber County Sheriff's Office for 20 years until I became director of the Weber Morgan Children's Justice Center. So this is a law enforcement professional who worked at Weber County in the sheriff's office, and he's writing a letter of support for Officer Colton Johansson, who was caught with child sexual abuse material in his garage, admitted to a polygraph examiner that he had that material in his private residence, and that he also sexually abused an infant in 1994. And Rod Layton wrote a letter of support pointing out, oh yeah, by the way, I was the director of the Weber Morgan Children's Justice Center. I just retired from there after 21 years. You know what Colton Johansson did before he became a school resource officer at Ogden High School? He worked the Special Victims Unit for the Ogden PD. And he took the material that he obtained, the evidence that he obtained, to his house and kept it there. Now, he didn't wade through that material to get the pictures of nude adults before he took it home. He just took it all home. And he wants us to believe that he only perused or viewed the material that depicted adults in a state of undress or adults in a sexually compromising situation, even though he admitted to sexually abusing an infant in Roy, Utah in 1994. Now, he could have pilfered out the adult porn out of that evidence locker that he wanted to take home, and maybe we would have believed him. It still would have been inappropriate. It still would have endangered any number of criminal prosecutions because he's breaking the chain of custody, which opens the door for any decent defense attorney to challenge convictions for sexual abuse. But he didn't do that. He just took it all there. And he wants us to believe, even though he admitted to sexually abusing an infant in Roy, Utah in 1994, that he didn't look at any of the child porn. He had, other than to go through it to determine that it was child porn, not the adult porn, he didn't take the adult porn out and segregate it from the rest of the porn before he masturbated to it. His story is such bullshit. It's unbelievable. But it is what it is. And Rod Layton co-signs him. Rod Layton, I formed the Internet Crimes Against Children Task Force in 1998-1999 after noticing a substantial increase in children being contacted through electronic devices. During my career, my best estimate is that I have been involved in approximately 15,000 cases. That ought to fucking disturb everybody. That ought to disturb everybody watching this. That Rod Layton, who's been in 15,000 cases, who was the director of the Weber Morgan's Children's Justice Center for 21 years, who formed the Internet Crimes Against Children Task Force in 1998 and 1999, is endorsing a man who took child porn home and who admitted to sexually abusing an infant in 1994. That ought to chill everybody's bones. Probably need to take a look at Rod's computers. In 1998, when I formed the Internet Crimes Against Children Task Force, I was alone in my efforts. I approached administrations from the Weber, Box Elder, Cache, and Davis County Sheriff's Offices, plus the Ogden City Police Department. None were supportive of forming a task force. I fucking wonder why. How many of them were sexually abusing infants or keeping child porn in their garages that they had obtained through child porn prosecutions or investigations? Given that Colton Johansson's ex-boss, the former Ogden City Police Chief, also wrote and appeared at his sentencing hearing in his support, probably a good many more than just Colton. Thanks to Reed Richards, past county attorney and past assistant AG for Utah, his help, we convinced admin to let us proceed. Between the two of us, we secured a $40,000 federal grant, and ICAC, the Internet Crimes Against Children Task Force, had its start in northern Utah. Once we secured the funding, I again approached police management. I asked for office space, office supplies, manpower, and their support. All refused to help, but gave me the go-ahead if I could make it work without using any of their resources. In the end, it was the Ogden FBI police office, or the Ogden FBI office, not local law enforcement, that agreed to help with the things we needed. There's your fucking sign, Utah. There's your sign. It takes a federal law enforcement agency to help with this. Everybody locally refused. Everybody locally refused to even start the Internet Crimes Against Children Task Force. They refused to give him office space or manpower or anything. The Ogden FBI office that agreed to help him eventually. A short time later, we moved into their office. The police chiefs and sheriffs, however, set restrictions. The investigators would not be paid. We could not use the evidence rooms to secure evidence, and they could only work after their regular shifts. They also restricted us from calling on personnel from the ID department to help with the technical support. Judge Conklin, hopefully this history will help you understand the challenges we faced as investigators. This is back in 1998 and 1999. Now, Colton Johansson's current boss, at the time that he was fired, the police chief of Ogden City, Chief Subi, directly disputed this. So here's Rod Layton saying, "Oh, by the way, you can't store the evidence to secure the evidence that you uncover as part of the ICAC, the Internet Crimes Against Children Task Force. We won't let, even if it's in our jurisdiction, we won't let you store that evidence on site um, in our evidence lockers or evidence rooms. We won't let you do that. That would be that sounds kind of fucked up, because it is. And of course, apparently you can't store it at the FBI's Ogden office either, which would be the logical place to store it. But according to Rod Layton, maybe that helps contextualize, even though it was like almost 30 years ago. Maybe that helps contextualize Colton Johansson's refusal to store that evidence in the evidence locker at the Ogden Police Department after he left the Special Victims Unit to become a school resource officer, which he shouldn't have had it in his possession at all at that point. But maybe this provides you some context as to why he had it in his garage after leaving the Special Victims Unit and after becoming a school resource officer who no longer investigated these kinds of crimes and really had no legitimate reason to store it at his home. Certainly no legal reason to jerk off to it in his home, which he admitted to doing. So it's undisputed. He admitted that he pleasured himself to the material that he took home. He just said, I had to wade through it and peruse it to find the adult porn in it. And theoretically, like, even the adult pornography, the pornography where adults were photographed in the nude or in various states of abuse or various abuse situations, theoretically those adults are victims as well. That's why it's evidence in a Special Victims Unit case. And so everything about this is not the excuse that Rod Layton clearly thinks it is. It does provide a pretty damning insight into Utah's attitude towards sexual abuse, because of all the obstacles that Rod Layton outlines here in terms of forming the Internet Crimes Against Children Task Force. Guess what? You can't use our IT department for any sort of technical issues that you're having. You can't store the evidence, even if it's a crime that occurred in our jurisdiction. You can't store it in our evidence lockers. That's Ogden City Police Department, Davis County Sheriff's Office, Cache County Sheriff's Office, Box Elder County Sheriff's Office, and the Weber Sheriff's Department. You can't store the evidence, even if it's in your jurisdiction. You can't store this kind of evidence in our evidence locker. And by the way, we're not going to pay your investigators, and we're only going to allow our employees to work on this task force after their regular shifts. So they did everything they could to make this difficult for ICAC. In fact, the only reason ICAC had office space to operate out of was because the Ogden FBI office lent them office space. And if you think things have changed over that time, they really haven't. Utah still has a 2.97% conviction rate for rape, has an under 13% prosecution rate for rape that is reported, and we know from the data that only a third of victims report their rapes. So hey, this is not the exculpatory thing that Rod Layton thinks it is. It's actually a pretty damning insight into how crimes against children are treated in Utah back then and even now. And he's using this to excuse Colton Johansson for having child porn in his private residence. He completely glosses over the fact that Colton Johansson fucking abused a kid, like an infant in 1994, by his own admission. So, he said, we worked for free, kept our evidence in a drawer or a cardboard box. We're constantly exposed to child pornography. I have personally viewed over 1 million images, and all without the support of our leaders. Colton was part of the task force and was no exception to the conditions we worked under. I'm sure any agent or detective that worked these cases has a box containing disc and images of child pornography. What the fuck? So what you're saying in defense of Colton Johansson is that he's not the only one breaking the law by taking this material home and keeping it in their personal possession, even though it's a fucking crime. And it wasn't really, working for free. I mean, when you're doing what you love, you don't need to get paid, right? When you're the type of guy who will forcibly sexually abuse an infant at 24 years of age, that's not a one-off. And it's no coincidence that Colton was part of your task force and had access to child porn. That's probably not a coincidence. That's probably Colton's compensation for all the work he did on your task force, is that he had access to this material, which he then at some point took home and stored in his house and admittedly masturbated to. I was deeply disappointed with the Davis County Attorney's decision to pursue these charges. What Rod Layton is saying, actually, we had a little technical difficulty there. The power went out. So I had to go fix that. Apparently a breaker tripped. Let's see, is the audio on now? If my monitor says it is. Richard, sorry about that. Ultimately, what Rod Layton is saying here is that after Colton Johansson, who worked on a task force under his supervision, took child porn home, masturbated to it by his own admission, although he wants to say he took the adult material out, and that's what he pleasured himself to. But he also sexually abused a kid, an infant, in Roy, Utah in 1984. Rod Layton is disappointed, deeply disappointed, with the Davis County Attorney's decision to pursue these charges. Like, when you're reading this, like, the intellectual incoherence, like, the cognitive dissonance is tremendous. Like, you're just sitting there going, like, do these people not understand what the fuck it is they're writing? Like, he admitted to the polygraph examiner that he forcibly sexually abused a kid, an infant, in Roy, Utah in 1984. Why would you be deeply disappointed with the county attorney's decision to pursue charges for that. He was fucking sexually abusing an infant. Like, why would that deeply disappoint you? That he was charged and prosecuted for that. It's a gut punch to me as the commander that after all we went through to establish the task force, that Colton was arrested for having discs that we were not allowed to put in evidence. Really? Over the entire almost 30 years that you operated that task force, policies didn't change to where at some point Colton could have stored that evidence in a locker? Hell, they could have left it at the Ogden FBI office where it would have been secured. There was no valid reason for him to take that material home. None. You had office space at the Ogden FBI office. You should have left that shit there. Because if you didn't, there's God knows how many prosecutions or convictions that are at risk because you broke the chain of evidence. Like you broke the chain of custody where that evidence was concerned. Every detective had a box containing evidence on cases they worked. Well, if they took it outside of the office and stored it in their private residence, they fucked up. It's illegal, even if you're a police detective, to take that shit home to your private residence. It also calls into question the integrity of the chain of custody where that evidence is concerned in criminal prosecutions. Oh, and here, he completely decimates his own position. Eventually, we did receive permission to use the evidence rooms, but there was no policy or requirement to do so. Yes, there was. The law clearly says you can't possess child sexual abuse material outside of your capacity as a police officer or detective, and you can't have it in your private possession at your personal residence. Judge Conklin, please consider the fact that the children whose images were on the disc often had not yet been identified. What the fuck does that have to do with this? So what if they weren't identified? Agents spend hours reviewing the disc repeatedly, sometimes for years, attempting to identify the victims. Well, when Colton Johansson was pulling stuff out to jerk off to in his house, was he trying to identify those kids? Was there any legitimate law enforcement purpose to what he did? Fuck no. This is something a county attorney's office would not understand. Oh, really? You don't think that they spend a lot of time trying to identify victims in criminal cases? Like, these agents, including Colton, were deeply passionate about finding and protecting these children. Well, I don't think he was deeply passionate about protecting children, given that he forcibly sexually abused an infant in 1994. I'm sure he was passionate about finding the kids in those images and video files, because they're already preconditioned to comply with fucking abuse. Hopefully you can now understand how discouraging it was when Colton was charged. Because, hell, he wasn't the only one who had that material in his house. I mean, some of us still have it. We all have boxes of evidence on cases that we worked in, and those boxes include child sexual abuse material. And you know what? We don't get paid very much. In fact, we weren't getting paid at all initially, so as part of our compensation, we just got to look at porn and jerk off to it on our own time. But don't worry, Judge. We were passionate about finding these victims, and it was dual purpose. When we pulled these discs out and we plugged them into the computer and we pulled this material up, it was dual purpose. In Colton's case, he was trying to find those victims. He was also letting a little steam off by jerking off to that material. Like, under state statute 76-5B-201, 6B, it states that a law enforcement officer is not criminally liable for possessing child sexual abuse material if acting within the scope of a criminal investigation. He was jerking off to the material in his house. He wasn't acting within the scope of a criminal investigation. He wasn't even a special victims unit detective or employee at that point. Like he was a school resource officer at Ogden High School. What the fuck are you talking about, Rod? Like, fucking seriously. What are you talking about? Like, he didn't possess that material within the scope of a criminal investigation. He possessed that material because he was going through it to jerk off. Like, that's the reality of it. That's what this is about. And he got 30 days with credit for 2 days of time served, so 28 days in jail for this shit. Not just the child porn that he had in his house, but for forcibly sexually abusing an infant, which, by the way, Rod doesn't get into that. It's just, Colton should be prosecuted for having child sexual abuse material because he was a Category 1 police officer when arrested and charged. The statute is clear that he was not criminally responsible for having the disc. Well, that's kind of the issue. This wasn't connected to a criminal investigation that he was an active part of, and even if it was, there's no part of a criminal investigation that involves jerking off to evidence of child sexual abuse or even adult sexual abuse. This was conveyed to the Davis County prosecutor. However, they disagreed on the basis that the discs were old and not part of a current investigation. No shit. No shit, Rod. They did, however, charge Colton with tampering with evidence. The statute requires that the tampering must involve a pending case. Judge Conklin, Colton was not in violation of the law, but was arrested and charged anyway. What the fuck are you doing, Rod? Is this the hill you want to die on after 21 years of service? Like, you just retired? Just, most normal people would back away from Colton and just be like, I can't fucking be associated with that guy. You decided to die on this hill by saying, oh, Colton didn't really tamper with evidence. Yes, he did. You know how many convictions you put at risk when you take evidence with you to your house and you break the chain of custody? And when you're, by your own admission, jerking off to that evidence? When you yourself, as an officer of the law, forcibly sexually abused an infant in 1994, you know how much that calls into question your testimony at criminal trials? Any enterprising defense attorney who represented a client where your testimony was part of their criminal conviction for possession of child sexual abuse material or for sexually abusing a child in any way, any enterprising defense attorney would go back and say, hey, my client didn't get a fair trial. And the guy who's testifying against him, he's a fucking abuser himself. He's contaminating evidence. He's tampering with evidence. And my client didn't get a fair trial. And my client's conviction should be overturned as a result of this misconduct on the part of the law enforcement officer who was part of his trial, who was part of his investigation. Judge Conklin, Colton was not in violation of the law, but was arrested and charged anyway. The most disturbing part is the police report states that Colton stole the disc. In other words, Detective D. Piles falsely claims that the disc were stolen. Page 5 of the Davis County Police Report, which now satisfies 76-5B-2016B, There was never any evidence concerning the theft of any disc. He was authorized to have them and should not have been arrested or charged in this case. Tell me the legitimate law enforcement purpose of a school resource officer at Ogden High having that material in his possession. His current boss, Chief Suby, or his boss at the time, Chief Suby, said, there has never been a policy, practice, or authorization permitting an officer to store evidence, including child sexual abuse material, at a personal residence, in a vehicle, garage, or any other non-secure location. Any suggestion that such conduct was permitted, accepted, or consistent with department practice is inaccurate. So somebody's lying here. Chief Suby is lying, or Rod Layton is lying. And the fact that Rod Layton ran a loose ship at the Internet Crimes Against Children Task Force, which he formed in 1998, and he allowed his detectives and his investigators to take this material home in boxes, isn't an indication that this is legitimate policy, or that it excuses the investigators who did take it out of that FBI office to their personal residences from culpability. It doesn't excuse them from culpability at all. What it does do is provide an insight into how Rod Layton ran ICAC. Like, it's fucked up. So, Rod Layton's deep disappointment aside, when I read this, I am just I'm almost speechless. I can't be speechless because I hate dead air in my live streams, but it's fucking stunning that a retired law enforcement officer who specialized against crime in crimes against children, sexual abuse cases, would write this letter on behalf of someone who forcibly sexually abused an infant, and to say he shouldn't have been charged with possession of child sexual abuse material. Colton worked ICAC cases for 8 years. For Davis County prosecutors to ignore the children he has saved and protected over the years is disheartening. Well, his actions call into question the integrity of every conviction he was a part of. Task force members worked hard over the years to apprehend those individuals that created, collected, and traded child porn. To lump Colton into this group make a mockery of the good work that was done with him and the other agents involved. Yeah, I don't think it does. Colton admitted to forcibly sexually abusing an infant. That is something that you don't mention, Rod, in your letter to the court on his behalf. Judge Conklin, I apologize for the length of this letter, not the fucking substance. But I feel it's important that you know. Three other issues that I feel need to be addressed. The violation of Colton's Miranda rights. Colton responded to the Ogden Police Department at the request of his supervisor. Once there, his truck was seized and the keys taken along with his phone. He was placed in a room for interrogation. Meanwhile, a search team was waiting at Colton's house to begin the search. According to a police report from the Chief Deputy T. West, chief deputies do not execute search warrants. Page 18, it said, Colton Johansson was not on scene and in custody with detectives. The chief deputy over the investigation division understood that Colton was in custody. Colton was never given Miranda at any time during this interrogation, clearly a violation of his constitutional rights. He was questioned about the location of the disc and at one point asked to draw a map, which he did. The fact that he was questioned without Miranda rights being read to him and that information used to search and locate the disc is fruit from a poisonous tree, which makes the recovering of the disc invalid and therefore should be tossed out. Well, unfortunately, Colton's initial admission of his criminal activities occurred in a polygraph exam where he was not required to be Mirandized. He voluntarily admitted to this criminal activity because he was flunking that polygraph examination. So the examiner paused the examination and asked him, why are you sucking at this polygraph, Colton? And Colton told him, oh yeah, back in 1994, I forcibly sexually abused an infant in Roy, Utah, and I have this child porn in my garage on disc, not pictures. I have to plug this into a computer in order to jerk off to it. But don't worry, I don't look at the children. I only look at the files that depict adults in a state of nudity or a sexually compromising position. You just take my word on that, even though I have a prior history of, like, fucking with a kid sexually. He admitted that to the polygraph examiner, which kind of obviates, it provides the basis for a warrant. So chief deputies do not execute search warrants. Well, somebody who did execute search warrants executed a search warrant at Colton's house, and they had a valid reason to obtain that search warrant because Colton Johansson didn't invoke during that polygraph examination when it was paused. He freely and voluntarily divulged his criminal activity. I don't know what Rod Layton is trying to do here other than exculpate Colton Johansson. He said, he goes on the site, Detective Woodward, in his report on page 16, second paragraph, we spoke about general topics like Colton's job, police work, living situation, etc., but did not question him about the crimes being investigated. Well, no shit. That's why they didn't Mirandize him, because they weren't talking about the crimes. They weren't talking about the crimes, and therefore they would have had no need to Mirandize him. He wasn't under arrest. Just like he wasn't under arrest when he disclosed his criminal activity to that polygraph examiner, which in turn triggered the polygraph examiner to report it to the Ogden police, who followed proper procedure, disqualified themselves from the case because they were conflicted out, and the case got reassigned to Davis County Sheriff's. Judge Conklin, the fact that Davis County Attorney's Office had no issues with Colton's constitutional rights being violated speaks volumes. The fact that you think his constitutional rights were violated speaks volumes. Like, you're either fucking inept or being willfully disingenuous, Rod. The detectives have already questioned him and obtained critical information pre-Miranda. You go on to say, you cite the detective's report. We spoke about general topics like Colton's job, police work, living situation, etc., but did not question him about the crimes being investigated. No shit. Either, if that's the case, they had no reason to Mirandize him. If he, was being questioned about the location of the disc, which, by the way, you say is not a crime for him to have those discs. There's no reason to Mirandize him. If he's not under arrest, there's no reason to Mirandize him. Like, this is not what you think it is, Rod. You're making the case for him to be questioned, this isn't a violation of his constitutional rights at all. Like, at the end of the day, the police did everything by the book. How can they not be held accountable as they should be? So you're arguing that the police and the Davis County Attorney's Office should be held accountable, but Colton should be. This is a 21-year head of the Morgan and Weber County Children's Justice Center writing this letter. That ought to be fucking disturbing to everybody. Search warrant. The search warrant appeared to be properly examined and signed by Judge Nieder. Please understand that I have a great deal of respect for her and greatly appreciate my association with her over the years. My issue is not with the warrant. Well, then what the fuck is it with? The warrant clearly describes the items they were searching for as a box containing case files belonging to Weber County Sheriff's Office or any other agency. During the questioning of Colton, without Miranda, as to where the box was located, he describes its location and drew a map. Once on the scene, the detectives walked directly to the described location and quickly located the box as described by Colton. It was exactly where he said it would be. There was no probable cause to continue the search authorized by Judge Nieder. Detective Kirkman, page 14, last paragraph, states, Detective Piles informed me of further disclosure from Mr. Johansson during his question. Based on the information gathered, we believed we had obtained all relevant evidence. However, Judge, this was not the end. They continued to search, throwing items on the floor, going through his gun safe that they had threatened to cut open if Colton didn't give them the combination. Items that had no evidentiary value were thrown around the room. A stack of LDS tithing receipts sitting on the dresser were tossed and scattered on the floor. Well, the warrant says they're searching for a box containing case files belonging to Weber County Sheriff's Office or any other agency. And they found that box, and it's reasonable to infer that there might be additional files. They might need to search for additional items that are specified in the warrant. Case files belonging to Weber County Sheriff's Office or any other agency. Which, by the way, Colton had previously admitted that he was jerking off to those case files. Like, he was using them for his own personal gratification, which is outside the scope of any legal basis for him to possess that material or use or access that material. And he did that of his own volition at a polygraph examination. But, you know, according to Rod Layton, this is an egregious violation of Colton's Fourth Amendment rights. You know, because they continued to search after they located the initial box that Colton drew a map to. They threatened to cut open his safe if Colton didn't give them the combination in pursuit of case files belonging to Weber County Sheriff's Office or any other agency. Because here's the thing about people who possess child porn or items that they're not supposed to possess. They have no legal basis to possess. They lie. They don't tell you the whole truth, which is why you get a search warrant that entitles you to search their home. The most obvious indication that the search was not about evidence was very personal, was boxes of ammunition dumped from their containers all over the room. Earlier in the search, when the deputies first arrived, they talked with family members about their association with Colton on the SWAT team. Judge Conklin, this search team included a sergeant, captain, and chief deputy, plus detectives. Having the Davis County Sheriff's Office administration on the scene is highly unusual and is clearly unnecessary. Well, that's because they're the investigating agency, and Ogden City Police were conflicted out because he was an employee of Ogden City Police. Law enforcement is already viewed by the public as unprofessional. Well, your disclosure that your investigators at ICAC were taking child sexual abuse material home in boxes doesn't help the public's view of law enforcement as unprofessional. Rod. Like, when I read this, it's fucking stunning to me that he wrote this. He put this down on paper. This certainly adds to the argument and was very disappointing. I served lots of warrants as the commander of ICAC. This was not the standard. The conflict of interest in this case is obvious since both the prosecutor and the detectives knew, and some even worked with Colton. This conflict could have certainly been avoided. From the search, it's obvious that the investigation was about making a statement and not an effort to protect children. They convicted him of forcible sexual abuse of a child. they obtained evidence of child sexual abuse material illegally in his possession. And then Rod gets to the bread and butter. I will conclude with addressing the aggravated sex abuse child. The reason we investigate sex abuse cases is to protect the victim and address further concerns of abuse. In the thousands of cases I have reviewed or investigated, my goal was not to destroy the family dynamics. This appears to be what has happened in this case. There are no victims. What? If there's no victim, how did he forcibly sexually abuse an infant? You spent 21 years at a children's justice system as the person in charge, and you don't believe that forcible sexual abuse has a victim. There are no victims, and there is zero concern about repeat offenses. There ought to be. If you think that Colton Johansson stopped at one fucking infant at 24 years of age, or at one child at 24 years of age, you're a fucking moron, Rod. The Davis County attorney has not produced a single item of evidence where a child has been abused or harmed. Well, if that were the case, Colton wouldn't have pleaded guilty to forcible sexual abuse. The probability that this case would have been bound over to a preliminary hearing is extremely low in my opinion. Unfortunately, if Colton had gone in that direction, Davis was prepared to add additional charges. The cost to defend himself was estimated to be between $30,000 and $40,000. This isn't possible for Colton to do. Well, Colton could file a motion for a public defender. This entire case was the result of a simple job interview that I also find highly problematic. The information gathered in the interview was from a polygraph exam given by a state trooper who is a Category 1 police officer. An officer is required to follow due process during a criminal investigation. Well, at that point, it wasn't a fucking criminal investigation. It was just a polygraph exam that was part of a job interview process. I was taught by a wise judge that an officer cannot give up, quote, the color of the law, end quote. This was not about a job offer from the state, but rather a criminal investigation without the burden of following the rule of the law. No, it wasn't. Colton voluntarily disclosed his criminal activity to this polygraph examiner. Polygraphs are not admissible, but in this case, it is the foundation of all Colton's charges. No, it fucking isn't. The foundation of Colton's charges is Colton's own voluntary admission of what he did. He forcibly sexually abused an infant in Roy, Utah in 1994. That's the fucking basis of this. He voluntarily disclosed that the reason he was failing this polygraph was because he had child sexual abuse material in his house, his private residence. So they didn't need to admit the polygraph results. All they needed to do was admit into evidence what Colton, by his own volition, had admitted to a polygraph examiner that he knew was a Category 1 police officer, a state trooper. You are either a police officer or a human resources employee, but they are not interchangeable. Any information gained from the job interview conducted by a police officer is not admissible. Yeah, it is, and it was, because you have the right to remain silent, but Colton Johansson didn't have the fucking ability to remain silent. Nobody made him disclose those criminal acts. He could have just said, I'm having a bad day. He didn't have to disclose the fact that he forcibly sexually abused an infant in 1994. He didn't have to disclose the fact that he had child porn at his house. Like Rod Layton here, the fact that he's a trained law enforcement officer and this is his position, strange credulity, but also, if this is how he views the Fourth Amendment and probable cause, he was too fucking inept to be a police officer in the first place. If this is legitimately his opinion, not just him stretching things to get Colton Johansson through the loophole, if this is honestly how he views the Fourth Amendment and probable cause, he's a fucking idiot. He's stupid as shit. Like, Judge, again, I apologize for the length of this letter. Thank you for your willingness to serve as a judge. I work with the best. And he goes on to cite Taylor, West, Baldwin, Dutson, Lyons, Heffernan, and treasure my association with him over the year. Colton was an excellent child abuse investigator. I bet he fucking was. He understood perpetrators because he was. He spent many hours at the Children's Justice Center. He spent many hours at the Children's Justice Center. There's so much in this letter by Rod Layton which is intended to absolve Colton Johansson of culpability, but which should trigger additional investigations as to what the fuck Colton was doing during his time on the Internet Crimes Against Children Task Force, during his time at the Children's Justice Center. He is well respected by many in the field. That's kind of the fucking problem, Rod. Both Davis County and the Ogden City Police Departments were premature in making statements directly to the media about this case. I believe their intent was to satisfy the demands related to social media and to avoid negative publicity. Unfortunately, they failed to consider Colton's 30-plus years as an outstanding police officer. What the fuck is outstanding about your 30-plus years as an outstanding police officer when you forcibly sexually abused an infant, when you had child porn at your house in violation of the law, and you were jerking off to some of that material? He deserved due process and his constitutional rights, which he got. He got due process. Please feel free to contact me at any time if you have additional questions. Rod Layton. It gets even worse because the next person is Lachelle Watney, the principal of Edison Elementary School. So she wrote a character reference for Colton Johansson. And so if you're a parent of a child who attends Edison Elementary School, you probably want to take a look at whether or not your kid is safe there and whether or not the principal there has the kind of judgment necessary to keep your kid safe. So she met Colton in October 2022 at the Weber County Sports Shooting Complex. He was serving as one of the instructors while she was an administrator at the Utah Military Academy. So the Utah Military Academy developed an armed intruder response team. And she was selected as a member of that team, and Colton was one of the firearms instructors in her training. And she is now the principal of Edison Elementary School. And she had a good experience with Colton as the firearms instructor at the Weber County Sports Shooting Complex. She wrote this character reference for him, attesting to his, technical expertise as a firearms instructor, after knowing that he admitted to forcibly sexually abusing an infant in 1994, which, by the way, Rod Layton, the director of the Morgan Weber Children's Justice Center, says that's a victimless crime. There's no victim here. Yeah, he forcibly sexually abused an infant, but really, did that infant remember the abuse? They were a fucking infant, so there's no victim. That's the principal of an elementary school. Then there's Cliff Bell. He's Colton's longtime friend. He actually claims Colton as a friend after these allegations became public, and after it became public that Colton admitted to what he did. He'd voluntarily disclosed it. So Cliff Bell would like Judge Conklin and everyone to know that he has sincere conviction regarding Colton's character integrity as a person that he has known for more than 3 decades. And over the course of our friendship, I have observed Colton in many aspects of life, family, work, community, and personal challenges. Throughout that time, he has demonstrated qualities of honesty, responsibility, loyalty, and compassion for others. I'm sure he is very compassionate to that infant that he forcibly sexually abused in Roy, Utah in 1984. I'm sure it was compassion and loyalty and responsibility that compelled him to wade through disc of child sexual abuse material that he kept in his house illegally, so that he could find some spank bank material to jerk off to. No individual is without mistakes, but I firmly believe that in any situation presently before the court does not define the true character of Colton Johansson. In my experience, he is someone who learns from challenges, shows genuine remorse when appropriate, and makes meaningful efforts to improve and grow. I have seen firsthand a commitment to personal responsibility and a desire to be a positive influence on his family and community. It is my sincere belief that Colton Johansson is deserving of the court's consideration and compassion. I respectfully ask that you take this letter as a reflection of a man who, over 35 years, has consistently demonstrated good character and the capacity for a positive contribution to society. Yeah, he's consistent, all right. He consistently didn't forcibly sexually abuse the children. He only did that once. Like, get the fuck out of here. His neighbor and friend, Chad Roberts, cites that Colton adopted a kid named Alex. And one of his children I am with on a regular basis because I work with him. His name is Alex, and his life has been amazing to watch because he was adopted through the state adoption program. Like, why the fuck would you go there, given these allegations? Colton received full custody of Alex after going through a divorce and really did all he could to help him. Alex was born with fetal alcohol syndrome and had some physical challenges and more severe mental challenges. He never made excuses for Alex, rather worked with him and helped him become productive and helped him overcome a lot of his challenges. Colton has been an amazing example to him. Forcible sexual abuse, possession of child porn, has helped him become a very productive young man, now 21 years old in society. He helped him get through high school and helped him understand what it takes to be a reliable employee and be someone others can count on at home or at work. My favorite thing about this entire situation is that Alex loves his dad so much, looks up to him, and has great respect for him. Not a day goes by at work where I do not hear Alex talking about his dad. Well, statistically, children who are adopted or fostered have a far exponentially higher likelihood of being sexually abused, being abused, period. And when those children, coupled with adoption, have a physical or cognitive disability, like fetal alcohol syndrome, and all of its concomitant physical and mental challenges, the odds that they will be sexually abused go up even further. But hey, maybe Colton altruistically adopted Alex and achieved, full custody of him after his divorce because he was just genuinely interested in Alex becoming a great human being. I have been with him, Colton, as he helped in the scouting program, been to several scout and youth camps, and has done countless service projects and career development activities to help the youth in our area. He has always been someone who will go out of his way to help others, especially children. This is fucking mind-boggling. This is in the record. Any journalist who covered this case could have gone through and found these letters. They're public. They could have found it, downloaded, and covered it. Elizabeth Roberts is next, and she goes on to wholeheartedly endorse Colton. He has also made a meaningful impact on youth in the community. I bet he has, by working with them and teaching self-defense and personal awareness. His focus has always been on helping young people protect themselves, except for that infant that he forcibly sexually abused in Roy, Utah in 1994, and those kids whose child sexual abuse material was stored in his house illegally. His focus has always been on helping young people support them, or protect themselves, build confidence, and make responsible choices. And who better to teach a child to make responsible choices than a guy who commits forcible sexual abuse on an infant and stores child porn at his private residence? I mean, what the fuck? So, Eric Kirkman. I first met Colton when I became a police officer in Ogden, Utah. I really began to know Colton when I became a member of the Ogden Metro SWAT team. He was a team leader when I began and was a big influence on my police career, SWAT career, and later became like a big brother to me. He is still someone who is involved in my life and someone I admire, respect, and look up to. Oh, despite the fact that he admittedly forcibly sexually abused an infant in 1994 and had child porn in his private residence. Like, I have no fucking words. The fact that this many people wrote letters of recommendation to excuse what Colton Johansson did or to get him a lesser sentence is fucking stunning. And a lot of these people are, there's Zach Barton, lieutenant in the Salt Lake Police Department. Ogden High School, Natalie Day, who is a teacher at Ogden High School. She wrote a letter, a character reference to Judge Conklin for Colton Johansson, which, if your child is in Natalie Day's class at Ogden High School, you should probably look into pulling that child out of Natalie Day's class. And she wrote her letter on Ogden High School letterhead, which I don't know who her bosses are at Ogden High School, but maybe they want to talk about that with her. That's fucking stunning. He got 30 days in jail, 2 days of credit for time served, so 28 days in jail. In the meantime, a guy who didn't build pools that he was, entered into agreements for, that would be Robert Patrick Riley. He's facing up to 60 years imprisonment and $295,000 in restitution, and Colton Johansson for forcibly sexually abusing a child and illegally possessing child sexual abuse material, which he procured by abusing his position as a member of a special victims unit and an Internet Crimes Against Children task force. 30 days. 30 days in jail, not prison. Jail. And 60 days of home confinement with GPS monitoring. That's why this state is fucked. And if you think it's like, if you think it's bad in terms of like child sexual abuse material, I got news for you. The judge in my case who wrote the memorandum opinion in my stalking case is Judge Randall Skanchy. And he was a substitute judge. He was moved in because they were short a judge. Judge Marvin Bagley, who was originally over my case, he retired. And he kicked the evidentiary hearing out several months from my initial hearing in August to like late November after his retirement. So Judge Skanchy was one of the judges that filled in on my case. I think there were like 3 or 4. And Judge Skanchy has made the news because he gave quite the lenient sentence to Alejandro Mendoza, who was charged with murder, but got a plea deal to reduce charges of manslaughter and aggravated burglary. And so for manslaughter, for killing someone, Judge Randall Skanchy sentenced him to 2 terms of 1 to 15 years in prison, but he suspended the sentences and ordered Alejandro Mendoza to serve 5 years of probation. Now, for those of you who are unfamiliar with the story of the murder of Jorge Llamas, he had a dispute with his girlfriend. He was 21, and he kicked his girlfriend, Ariana Aguiar, of Ogden, out of his house, told her to leave. So Ariana Aguiar didn't want to leave, didn't want to take no for an answer, so she contacted a group of teenagers, including her daughter, and she said, you need to rough him up. You need to scare him. And so there were 7 people in total involved in this, and they came to his house, Jorge Llamas' house, where he was sleeping. They stormed into that house, stormed into his room, and began to assault him, and one of them shot him in the neck. And when the police arrived, they found Ariana Aguiar, his girlfriend, on top of him. She told the police that the shooter got in through the window. She didn't know who shot him or where the gun was. Basically lied about her role in it. She got these people to come to Jorge's house. At least she intended for him to get beaten up. One of them brought a gun and shot him in the neck. They killed him. And the problem for everyone involved in this is that if someone dies in the commission of a crime, you are liable for their murder. Now, premeditation is generally the prerequisite for a first-degree murder charge. At the very least, these people are guilty of second-degree murder. But of course, because it's Utah, one of them, Alejandro Mendoza, who was 17 at the time, originally charged with murder and aggravated burglary. He was also charged with obstruction of justice. Ariana Aguiar, the woman who is responsible for all of this, she was charged with murder, aggravated burglary, and 2 additional counts of obstruction of justice because she lied to the police about her role in it and sent them on a wild goose chase when she knew exactly who had shot him. And she got charged with retaliation against a witness because there was a woman who was present at the scene of the crime, Mr. Llamas' residence, and when the police left her out in the living area while they were investigating the crime scene. Ariana Aguirre began to assault a woman who later told the police that she had been kicked out by Jorge Llamas. And these people had stormed in the house and ultimately killed Jorge. And so, of course, Alejandro Mendoza, under Judge Skanchy's view, merited a suspended sentence for killing a man, for being part of a mob of teenagers that murdered a man in his own bed because he was having a dispute with his girlfriend. And of course, Ariana Aguirre was busted because Jorge Llamas, his family received a text message from Ariana Aguirre, who confessed that she had been a part of this and that their relative had died as a result of the actions that she set into motion. So 1 to 15 years for murdering another human being. And the prosecutors, dead to rights, they had a witness to these people storming into the house illegally and assaulting and murdering Jorge Llamas of Taylorsville, 21-year-old man, because the woman he was dating had a problem with the fact that he kicked her out of his house. And so she got a group of teenagers together to burglarize his house, break into it, assault him, and shoot him in the neck. And kill him. 1 to 15 years. 1 to 15 years. By the same judge who lied in his memorandum opinion about me and said that I had leaked Joe and Lee Bennion's home address, and I did not. I didn't publicize or publish their current home address in Spring City. What I did do in order to demonstrate the credibility of the Hamlin sisters was show that he did live across the street from David Lee Hamlin at one time, using publicly available property records that anyone can search online in San Pete County. This is publicly available information. There's nothing private about it. You can search those property records to find out what those girls are saying. I also publicized David Lee Hamlin's old address in Spring City to demonstrate the credibility of his accusers and to show that what they were saying was plausible and on some level corroborated as to the essential allegations of the location of their abuse and the proximity of their father and his alleged co-chieftain in a Native American church that they had both founded as LARPing white men. That's what you're dealing with in this state. Jonathan Beestrom, 1996, my newspaper covered the story of a man who sued the Winnebago County, Illinois court for a judge molesting his wife when a foster girl. He was arrested and spent a year in jail. We got him out. Well, John, you're doing the Lord's work there. And you're also illustrating a point that I've made time and time again. It's not just Utah, but Utah is where I live part-time, and hopefully that's about to change. We showed our house yesterday. So hopefully someone buys it, and we get the fuck out of here and go back to sanity in the South. Because I got to say, this is stunning. you get more time for defrauding people of their money for building a pool than you do for forcible sexual abuse of an infant. And then you have a guy who's over the Morgan Weaver criminal justice or children's justice center saying that there's no victim in forcible sexual abuse because I guess the victim was an infant and didn't remember it and therefore wasn't affected by it because they were an infant and they were too young to remember. So there's no victim. Well, there are plenty of victims on those discs of child sexual abuse material that Colton Johansson took home without any legal justification for doing so. He was a school resource officer. At the time, he wasn't an SVU investigator. He wasn't an ICAC investigator. And even then, evidence is supposed to stay in the evidence locker at the police station, or if what Rod Layton is saying is true, at the FBI office in Ogden is where it should have been stored, in the offices that were provided. It's just that simple. And the fact that it wasn't is indicative that Rod Layton wasn't running a professional operation in the Internet Crimes Against Children Task Force that he formed and founded in 1998. There are probably a lot more Colton Johanssons out there who used Rod Layton's lax supervision to access child sexual abuse material and to take it off-site to their private residence and do God knows what. That's what we're dealing with in the state of Utah, and that's why this state is screwed. It's one of the many reasons why this state is screwed. So I will open it up to kind of the Ask Me Anything section of this live stream in order that those who are still currently viewing can ask me any questions they have about this or other matters pertaining to IRA subject matter. But the purpose of this episode was to outline specifically what's going on in the state and why perpetrators get lax sentences and why their victims, on the other hand, are dismissed altogether or stigmatized for coming forward. And maybe that has something to do with the fact that most victims in Utah don't report their abuse because they face greater stigma and greater consequences for reporting than their abusers do. I mean, there's teachers, principals, law enforcement. These people all wrote letters urging Judge Conklin to provide a more lenient sentence for Colton Johansson. They didn't run away from Colton Johansson for what he did. They basically doubled down from his children on down and unintentionally revealed a lot of the dysfunction. Have you found any prosecutors in Utah that will prosecute? In the Hamlin case, no. Utah County Sheriff's Office says they still have an active investigation pertaining to Hamlin and his accomplices. That's the justification that they employ to deny a grammar request, even though one of those cases, the Sheets case, has been dismissed with prejudice, which means that it will never be brought to court again. It'll never be brought to trial again. They have refused to release any material related to that case. And when you file an appeal in the state of Utah over the denial of a grammar request, the county level officer that you appeal to doesn't even acknowledge your appeal, doesn't respond at all. And since the state legislature disbanded the statewide board that fielded those appeals, there is no recourse. I mean, I'd have to raise tens of thousands of dollars and go to court to fight UCSO. And I have zero confidence in the court system in Utah for the reasons that I've outlined in this episode with respect to Judge Conklin and Judge Skanchy and others in prior episodes. At the end of the day, the title of this episode is Why Utah is Screwed for a Reason. Because you and 6 other people can break into a man's house while he's sleeping because his older girlfriend puts you up to it, falsely accuses him of hitting her, doesn't call the police to file domestic abuse. She rounds up 7 teenagers or 6 teenagers to storm his house, assault him in his bed, and one of them shoots him in the neck and kills him. And you get a suspended sentence of 1 to 15 years for manslaughter. Not murder. Manslaughter. Even though you shouldn't have been in his house in the first place and you were engaged in the commission of multiple felonies when you broke into his house, assaulted him in his bed, and ultimately it led to one of your accomplices shooting him in the neck and killing him. Like, there's ample evidence to charge these people with at least second-degree murder. And they dropped the charge to manslaughter because Utah is a sanctuary state for people who murder and rape and torture and abuse others. That's the fucking reality of this state. And that's why you should get out if you can. Like, that's, my wife and I are getting out because this state is insane. It's not just insane with respect to sexual abuse. It's insane with respect to violent crime. And they very clearly want their law-abiding citizens at a disadvantage. The people who pay taxes, you're expected to pay for whatever policies they ram down your throat. If you own a home here, you know, your property tax can go up by 25% or more year over year. That's what happened this past year in our county. I'm here part-time, and I still have to pay full-time property taxes. Like, at the end of the day, that's what this is. It's a big part of the reason I never wanted to live here permanently. Because I knew from the Hamlin case that things were really terrible here with respect to the criminal justice system. But what I have realized over 4 years of dealing with Hamlin and almost 2 years of living here even part-time is that it's worse than I ever imagined. And this Colton Johansson case, it isn't isolated. This Alejandro Mendoza manslaughter case with a suspended 1 to 15 year sentence, it's not isolated. This is far more common than people would like to acknowledge. You can kill somebody and get a 1 to 15 year suspended sentence by the same judge who falsely put in his memorandum opinion that I leaked the current address of Joe and Lee Bennion, who even after Joe Bennion, under cross-examination in front of him, when I went through each individual act listed in every section of that stalking statute and got him to say, no, I don't have any evidence or proof that you did any of these acts. I went down that with him in detail, and each time he answered no, because I didn't do any of those things. And the statute requires 2 or more acts directed at a specific individual. Well, that specific individual who showed up and testified that I was able to cross-examine specifically denied having any evidence or proof that I committed a single one of those acts. And I still have a permanent stalking injunction, and they are using it to regulate content. Every single time I mention their names, they want to go to court, and they want to say that that's a communication directed at them, and it's causing them emotional distress. So ultimately, it isn't content neutral. It is content-based censorship under the guise of a spurious stalking injunction. That's what's going on in the state, because the real crime that I committed wasn't stalking. I didn't stalk those people. What I did was report on publicly available allegations and documents that allege that they are child rapists and ritual abusers. And at the end of the day, like at my initial hearing before Judge Bagley, before he retired, he said to me, "You called them Satanist," as though that was a justification for what was going on. At the end of the day, I either stalked them, I either committed acts in that stalking statute, 2 or more acts directed at a specific individual, or I didn't. And I didn't. And so, to basically intimidate me into not reporting on allegations against these 2 particular individuals, they awarded a stalking injunction. I paid a $1,000 fine, down from $45,000 that they were threatening me with. They've been threatening me with jail time for reporting on this. With respect to these 2 individuals, my latest offense is that Joe Bennion came to my Facebook page and reposted my content, and I said, he who shall not be named is reposting my content, and put a screenshot of it, and they say that's a violation of the stalking injunction. It's communication directed at Joe Bennion. It doesn't tag Joe Bennion, doesn't. If Joe Bennion weren't coming to my page, he wouldn't know anything about it. But there's an individual who's been harassed, calling me like potato nigger and shit on social media. His girlfriend is apparently doing the same. Like, I don't know if it's... He has a reputation for using sock accounts to harass people on the issue of ritual abuse. And by the way, when he was in a chat on our prior episode, and I asked him, "Are you opposed to child sexual abuse or child rape?" He said he wasn't going to answer the question, which is an answer. That's the caliber of people on the other side of this issue. And there's only one reason you would discount the existence of this type of abuse or the rate of this type of abuse, like the frequency of this type of abuse. It's because you're involved in it. And so when I look at people like Jonah Barnes of Word Radio and whatnot, I think it's telling that Jonah wants to pretend like this abuse doesn't exist. He wants to gaslight thousands of victims who have come forward and attested to this abuse happening, many of whom bring receipts, many of whom name abusers who have criminal convictions for child sexual abuse. Jonah wants to sit there and say that ritual abuse is just false memories and implanted memories, which he has no empirical basis for saying, either generally or specifically, because false memories are not validated by the American Psychological Association. It's not in the DSM because there is no empirical basis for it. And the 2 studies that are cited by Elizabeth Loftus and others, there's a Canadian woman, I forget her name at the moment, she's kind of Elizabeth Loftus's heir, haven't been replicable. And their underlying methodology, once revealed, served to debunk the scientific validity of their conclusions, which is that you can make people remember things that didn't happen. The Lost in the Mall study by Elizabeth Loftus is the most commonly cited study with respect to this. Study these days isn't replicable because it isn't valid. It's what I call pop science. And ultimately, it gets funded by corporate interest and whatnot, but it isn't valid. It isn't real science. It's junk science. In prior content that I've published on here under anti-tribe, fringe concerns, so on and so forth, I've highlighted the replicability crisis in the social and hard sciences, the natural sciences, to drive that point home. And I cited the work of a man at a Stanford University named Dr. John Ioannidis, who has made an entire niche out of discrediting junk science and showing that the majority of scientific studies can't be replicated because they aren't scientifically valid. On that note, since I don't have any questions in the chat, I would say this is a good place to cut things off. I'll give you another few minutes since we are on a delay to type any questions you have in the chat before I stop streaming in this broadcast. Going once, going twice, going 3 times. The people have spoken. Thanks for watching. If you could subscribe to Investigations of Ritual Abuse or Anti-Tribe or Fringe Concerns or Government Sex Predators, Church Sex Predators, we are reader-supported. We are donor-supported, so if you could make a donation, that would be great. Thanks for watching. If you could hit the subscribe button for Investigations of Ritual Abuse's channel on YouTube, that's going to help us get closer to monetization and get our content up in the algorithm, so please do. If you could share our content with other people, that would be great. That would be most helpful. So we'll see you next time, and we will talk to you next time on Investigations of Ritual Abuse.